Joan Arian presiding.
Thank you. All righty, we will take our last case of the morning and the afternoon. And it is Anthony versus Galvez. Mr. Anthony, you are
Yes.
Remote. Are you there, sir?
Yes, ma'am. Can you hear me?
I can hear you. Are you going to have video or no?
I was trying to.
Okay, we can give you a minute.
Is there a way to do that?
No? Just remote? Okay. Well, we can hear you, so why don't we go that way? You have...
Okay.
Sorry, I didn't hear you. What?
You hear me?
Yes, I can. All right, you have 15 minutes. Do you want to reserve time to respond to counsel?
Yes, ma'am. I would like to reserve at least 5 minutes. If I can complete my argument less than 10, I have been rehearsing.
All right. I will reserve 5 minutes for you. So go ahead, Mr. Anthony, and you can proceed.
Thank you, Your Honor. To the justices of the court, I appreciate the time on this matter. I do believe this appeal of the move away is central to a judicial abuse of discretion, as in Keith R. 174 requires immediate move back. There was no notice. There was no evidence of any notice. And there was plenty of opportunity as Ms. Galvez had counsel, which is contrary to the 3024 statute, which is a notification requirement. And there is no argument of the material facts considering the body-worn cameras, which has been presented to the court on this appeal and other appeals under CRC 8.46E, authorizes an in-camera review of those body-worn cameras, which I do believe is the central element to this argument, which was the triggering mechanism which allowed the move away to proceed by judicial abuse of discretion, considering the monumental and flagrant delicto of the manifest injustice, which can be summarized very briefly by page 85 of the September 2nd, 2022 transcripts, where the court makes a particular specific finding to having found a push. The court says on page 85, specifically particular to a push. Now, which is concerning because Ms. Galvez reported to the police in the body-worn cameras on August 5th, 2022, I was pushing Sean Stevens back. I was holding Sean Stevens back. But on page 33 of the same transcripts of September 2nd, 22, she denies that material fact, which the court made its findings specifically particular to an inconsistent testimony by her and Stevens. Stevens claims that he witnessed me push her with two hands like a push-up, whereas Galvez says I pushed her with my shoulder, which is mathematically and physically impossible based on the height differential, which would require me to be leaning forward at a 21.8 degree based on my 6'1" height and her 5'3" height. I would have to running and leaning forward in order to hit her with my shoulder. So
Mr. Anthony?
Yes, sir.
This is Justice Castillo. I have a couple questions for you. The first one is, you did not appeal the granting of the restraining order after hearing. Is that correct?
That is correct, and I'm very aware of your point. Yes, sir.
You also mentioned earlier and cited Keith R. and mentioned that the judge did not return the children to San Diego. Did you seek review or appeal that decision?
For the move away, yes, sir. That's why I'm here. This is for the move away. The move away was done entirely improperly, sir.
You understand that your burden is to establish that it was error and that we presume that the trial court's order, meaning that the move away, was correct unless you meet your burden to establish error.
Correct, and I do believe I have that particularized.
And can you summarize what it is in the record and in your briefing that establishes that error?
Yes, sir, and that comes down to Hazel Atlas class, Throckmorton, Marriage of Varner, Skinner versus Oklahoma, when there's fraud upon the court, when there's willfully, knowing, and intentionally false testimony that's given to the judicial officer, he is therefore stigmatized by that false testimony, and it's now fraud upon the court, which has, I believe, no statute of limitations. Galvez knew her testimony to be false, and she conspired with Stevens to commit that perjury to the court. Anyone who reviews the body-worn cameras, which is supplemented by the declaration of the custodian of records, which she says on the night of the claimed incident, I never saw a gun. I was pushing Sean Stevens. I was holding Sean Stevens back. Those statements defeat her entire argument. You cannot have a person who is running in, an MMA fighter, running in to fight Mr. Anthony, right, if he's armed. So they willfully and intentionally and knowingly concealed that testimony that they gave to the police. There's an inconsistency in the testimony. It's a material fact. It's fraud upon the court because she willfully, knowingly concealed those material facts in a sworn testimony. And she changed her story 5 times, which is evidence in the Register of Action. She first told the police, I never saw a gun. On the 6th, she told the police, he's armed and dangerous. He's hiding in the house, waiting to ambush us and kill us while I was at the movie theater. On Sunday, she says something similar. On Monday, she files a declaration saying something similar. He's armed. He pointed a gun at my friend. And then she testifies a month later, after she received the default judgment of the DVRO, oh, I never saw a gun. So now there's no recourse on Mr. Stevens, who's an out-of-state Arizona resident, who sent a UPS letter across state lines with threats concerning the children. The children's well-being is now my concern, not yours. So there's just so much here, ladies and gentlemen of the court, that is just, I think, an in flagrant delicto that the trial courts overlooked all these elements, that there was clearly a control issue by Ms. Galvez. There was never any concern of risk. And the courts mentioned in its December 8th review credibility concerns of Ms. Galvez. And that finally was evinced in July 30th of 2024 when the trial court granted my motion to compel and release discoverable evidence from the San Diego Sheriff's Department. Those body-worn cameras were released on July 30th, 2024, 2 years after the DVRO hearing of September. There would have been no evidence available for an appeal on the DV. The police had not released under subpoena and prior motions to compel, which are evinced in exhibit number 1029, declaration of Sean Jones, who tried and exhausted himself and his company resources to obtain that discoverable exculpatory evidence, which would have exonerated me from any wrongdoing. So I do believe the central object here for this court and any court, according to the legal standards of the Family Code 2121, authorizes relief from judgment if a judgment is obtained through fraud or perjury. Also, Family Code 6345 requires reasonable apprehension of future harm for renewals, which is presently before the court on another appeal. Lister versus Bowen, 2013, Cal App 4th, 319. The CCP 473D permits vacating void judgments with no time limit for fraud. Pumphrey versus KW Thompson Tool Company, 62F, 3D, 1128, 9th Circuit, 1995. Also, CCP 473B allows relief for newly discovered evidence of fraud within 6 months, extendable for fraud upon the court in the marriage of Stenvat, 1984, 154 Cal F 3rd, 1051. CCP 663 also permits setting aside judgment based on erroneous legal conclusions, which this is, and I believe, again, is simply evinced by reading page 85 of the court's finding. The court found particularly to a push, and there is fraud and there is perjury central to the push that Galvez is stating. This entire matter over 3 years in separation of my children at an expense of over $1 million is based on false testimony of a push. So I believe it's meritorious. And I believe the California Family Code 2121 grants this court the authority for review when there is no reasonable apprehension for any harm any future harm, and the newly discovered evidence, which was released on July 30th, 2024, clearly proves this is not a mere discrepancy, but a deliberate falsehood by Galvez. I would like to reserve any remaining time, if I may, and ask the court if it has any questions at this point.
All right, we will let you reserve your time, Justice Doe, Justice Castillo. Any questions at this point? All right, sir, you can reserve your time to respond, and we will hear from Ms. Cianciolo. Would you tell me that again when you get to the microphone?
Cianciolo.
Cianciolo. All right, we will hear him. If you would please state your appearance, and you are appearing on behalf of Ms. Galvez, correct?
That's correct, Your Honor. Linda
Alrighty.
Cianciolo for the respondent.
All righty.
I just want to address two things. Mr. Anthony keeps talking about a push. I would note that that was something from the restraining order hearing, and he never appealed that order. So he keeps bringing that up, but that order was never appealed. Also, there was a hearing on December 8th, also never appealed, where the court did make a decision based on Mr. Anthony's attorney's argument about having the kids come back, and the court denied that, along with denying a new trial on the restraining order. Also, I'm so sorry.
Sorry, Cianciolo.
Cianciolo.
I'm going to keep trying, okay?
You're good.
Regarding the December 8 hearing, I understand from the record we have on appeal that there was a request for order filed by Mr. Anthony. There was a reference to something about ex parte to have the immediate return of the children. Is it your understanding that the trial court denied that request for order, or did it decline to take action?
From what I remember out of the record, the very first time he asked was back and filed the RFO was back in 2019. On the December 8th hearing, there was no RFO. It had been or maybe his attorney did file one. I'm sorry, there's so many different, I have all the transcripts, but it was argued by his attorney to have the children come back. And this was post restraining order, and the court made a finding that she had left in August, and he found her credible as to why she left, and he was not going to order the children to come back at that point.
And that finding was that she left in fear.
That's correct, Your Honor. That's correct. And so he didn't find it would be in the children's best interest to come back. I would also, unless I was never provided it, there was no body-worn camera footage that ever came in.
Can we return to the December 8th hearing?
Sure.
What was the authority that allowed mother in this case to move the children out of San Diego in August of 2022?
That December 8th was post restraining order, and in the restraining order from September of 2022, she was given sole legal and sole physical custody of the children. She then had been living in their family house, and she left after the restraining order. They did file a motion then to do the move away in that same month, and in that same month, which was August of 2022, they reached a stipulation giving Mr. Anthony back possession of the house because she had been living there.
So what was the authority? Was it the TRO? Was it the request for after hearing? Was it the stipulation
That the court looked at on December 8th?
that allowed the children to move out of San Diego County?
I believe there was quite a bit of argument on that issue. There was no notice requirement in the marital settlement agreement that she provide notice. When it came up again, the court found that she was in fear and left.
Let me re-ask the question again. So what was the authority that allowed the children to move outside of San Diego County?
What case allowed that? What
A
the
case?
court looked at?
What authority?
Well, the court heard argument, and I don't know that the court listed a case. The court listened to Mr. Anthony's attorney's argument.
Let me ask this question. So if I understand the record correctly, the domestic violence incident, which gave rise to the issuance of the DVRO, occurred on August 5.
Yes,
On August 8, mother went to the family home she'd been living in with the children to do an exchange with Mr. Anthony, correct?
correct,
And on that date, she found herself locked out of the family home.
right.
He was arrested on that date, and immediately after that, somewhere on August 9, she left in fear with the children, some 80 miles to a confidential address.
Correct.
So the question I have is, her relocating, fleeing, or leaving San Diego County with the children, was that done pursuant to a court order?
It was done pursuant to the restraining order granting her sole legal, sole physical custody of the children.
Let me be more precise. Was there ever a court order issued that permitted her to leave with the children? And in your view, was one required?
I don't believe one was required. I believe she had sole legal, sole physical custody of the children. That was given to her on August 5th at the temporary restraining order. And then I know this was an argument at the later hearing that there was no requirement in their marital settlement agreement that she had to give notice before she could leave with the children.
Then,
And this,
then
sorry.
good.
And as I understand it, this was a concern that the trial judge grappled with on December 8, was the question of whether or not a victim of domestic violence who flees in fear is somehow required to make the decision of either staying in the county to be with the children or to be able to seek shelter. Was that a discussion that happened on December 8?
It was.
And then I guess ultimately, does none of this matter since Mr. Anthony has not appealed it?
That's correct. And the court did the whole transcript from that day, which I believe the court allowed to come in here to this first appeal. They talked quite a bit about that, and the court did find that based on that he found her fear credible and that understood why she left, because in his opinion, the safety of her and the safety of the children was paramount, and so he did not order her to come back.
May I ask a follow-up question? If, at least as I understand your position, if it was either the TRO or the restraining order after hearing, that as authority to allow her to move the children out of San Diego, then why was there a need for an RFO to formally request permission to move the children?
Only because in family court, you're best to file a request for order to make sure that all the I's are dotted and the T's are crossed. And so I believe that that was why they went ahead and filed that RFO for the move away was filed in the same month with the restraining order prior to the December 8th hearing, and actually prior to the restraining order, or just right after that.
And two more questions. And when the court eventually granted the move away in October of 23, the children had been living in LA since August of 2022, is that correct?
Yes.
And then finally, what tension, if any, is there between the restraining order and the move away?
What, tension?
Yes.
I don't know that there is any tension, or I'm not understanding the crux of the question.
It goes back to the earlier questions regarding the authority to move the children out of San Diego County. The tension being the authority to move them, either the restraining order or the move away, and whether there's a tension between both in order to formalize that move.
No, I believe that with the restraining order and the subsequent arguments raised to the court about having to bring the children back, which was after she filed her move away, and then the court stated that on the move away, there would have to be an evidentiary hearing so that both sides could bring in testimony and witnesses and whatever they wanted in order to talk about the move away on a more formal basis.
And that usually happens, that hearing usually happens before the children are moved out of the county.
Sometimes. Depends on the circumstances of each case and my experience.
Is there any published case law where the circumstances are similar to this case, where the children moved out of San Diego, out of county shortly after a restraining order was filed, and then the move away was granted? Do you know of any?
Not off the top of my head, Your Honor, I'm sorry.
You don't need to apologize. Thank you.
Counsel, under Andrew V., you're familiar with that case. I don't mean to put you on the spot. So under Andrew V., a family court cannot issue a order to allow the temporary move away of a child pending an evidentiary hearing. Are you familiar with that?
Yes, and I think that, I'm sorry, was there something after that?
Well, you might be answering the question that you're anticipating. So under Andrew V., it's clear that a court may not issue an order allowing a parent to move a child before a full adversarial evidentiary hearing on the matter, right?
Yes.
Is that what happened here?
I think that, back to the circumstances in this case, it was raised, and this case kept getting continued. And when they finally were in front of the court on December 8th, Mr. Anthony's attorney and the court and Ms. Galvez's attorney had a long discussion about whether the kids should be ordered to come back based on the fact that that she had moved to out of the county to the only place where she had family and support. And the court listened to all the arguments and decided not to order the children to come back, that it was not in their best interest to be ordered to come back to San Diego, that Ms. Galvez didn't have any place to live, there was no support here, and so the court allowed the children to stay with the mom outside of San Diego County, and there was already a custody and visitation order in place. So Dad was seeing the children.
I object. That did not happen.
Mr. Anthony, you'll get your turn to reply, but counsel has not completed her argument. And when she does, then I'll let you talk, okay?
Understood. I'm sorry.
All right, that's just the way it works up here, sir. All right.
Understood.
All right. Counsel, you want to have any more comment? Any
I
more?
don't think so.
All right, let me ask my colleagues if they have anything further. Nothing further, Justice Hope? Nothing further? All
Thank
right,
you.
thank you. All right, Mr. Anthony, it is now your turn. You have 5 minutes, sir.
Okay. Just to clarify, on December 8th, 2023, Judge Segura did say the words, "I don't want to ping pong these children around." That's on page 26 of the transcripts of the December 8th. He did not want to ping pong the children around, and there was never any discussion with parties about the children relocating. Matter of fact, page 72 of the deposition from January 6, 2023, Emma Bray, attorney for the respondent, attempts to conceal the fact out of the property early and had concealed the move away. Page 72, she answers for her client subordination of perjury by saying it didn't say, meaning that the stipulation didn't have any predication to the children relocating, which was page 4, section G of the property settlement agreement, which did require notification 2 weeks prior to removing the children from the home on any vacation. And there was a pattern and a history of conduct between the parties, which I believe is a matter of law, where there is a custom within the home when the parents notify each other of things that affect the children's welfare, well-being, and their nest, which was central to this issue. The children were ping-ponged around by Ms. Galvez. It was concealed. There was never any notice. And the concealment is evidenced in page 72 of the January 6th deposition, where she substantively makes an about face in her testimony where she admits to having moved out of the house on the 13th, which is supplemented by the exhibit submitted showing Busy Bee lock and key at the property, changing the locks, which matches her testimony where she says the day the locks were changed is when I moved out. She concealed this. There's attorney misconduct on this. It placates the issue. There was an abuse of discretion on ping-ponging the children around. And I do believe that's evinced because there is no supporting case law which allows a retroactive move away to be conducted in the state of California. There is notice required. My mail was interfered with. There was never any notice. And there is clear evidence that attorney misconduct and Galvez's misconduct was meritorious to substantively conceal and underhanded dealings of the move away. Nowhere in the stipulation is it mentioned that it changes page 4, paragraph G of the children's residential habitat, which is in San Diego County. Never on any documentation was it confirmed between the parties that the children would be moving. And this, I believe, underscores the retroactive move away, which is a judicial credibility, judicial discretion abuse that affected my children. And the reason for my appeal and the reason for this appeal of the move away, there is no prior evidence of any kind of any prior domestic violence, of any abuse, of any physical abuse. The only evidence which is of record is diplomatic negotiations between the parties, in which is evidence of the MSA from July 11th, 2019, where I am then giving her the opportunity to do things that are completely contrary to my initial filing on May 2nd. I was a fear of my life that she would take the children and disappear with the children to Mexico. That was my original filing on May 2nd, 2019. July, a few months later, I am now in agreement to let her take the children to Mexico. One must ask the question, why would a person do this thing? And the simple answer is to keep the peace. I have demonstrated what I call the Magnificent Seven principles of diplomatic negotiations with Galvez to keep the peace, to keep the children in their nest, in their home, to sustain their continuity, which was violated by her violating the PSA agreement by bringing this MMA fighter into the home unannounced, without notification, which disrupted the harmony in the home, which disrupted the children's presence, in which she then relied on obtaining the DVRO so she could then segue to this move away, which was done retroactively.
All right,
I do not
Mr. Anthony, your time, sir, is up.
I understand. Thank you.
All right, thank you. The matter will be submitted, and there will be a written decision issued within 90 days. Thank you very much, and the matter will be, the court will be in recess until tomorrow morning.
Thank you, Your Honor.
Thank you.